just the sheer amount of work that gets done by faith-based nonprofit organizations, educating our children, feeding our hungry, and housing our homeless, and taking care of single mothers who are in problematic circumstances all across the board. The amount that's done for society by religious organizations is huge, and so unchaining them so that they can actually do this work without spending their time and their resources on all these administrative burdens and the fear of lawsuits and all of this, it's a really huge difference, not just for the good of religious organizations themselves, but for society at large.
All gathering here early for some folks on the West Coast, but want to just welcome you all to we're very excited for our third annual Faith and Freedom Index launch day. Lots of work has gone into this. I'm Mark Rohlena, Napa Legal's president. And as I said, this is our third report analyzing and scoring state laws that affect faith-based, federally tax-exempt nonprofits across all 50 states in Washington, D.C. So I'm going to avoid any spoilers. We'll save that for the meat of the presentation here. But so much work goes into this. So it is important to thank the folks on our team, Frank DeVito, our senior counsel and director of content, as well as our co-founder and vice chairman, John Peiffer. They're going to walk through some of the substance along with at least one special guest. But we can't go further without expressing thanks to them, to Joseph Clement, Helen Rothfuss, and all who have helped us get to this day. And really a special word of thanks goes to Mary Margaret Bush, who was our longtime executive director and VP. And she, of course, had a hand as this took shape and got launched and right up until the point where she joined the administration for the Commission on Religious Liberty. So excited for you all to be here. I am going to turn it over to Frank DeVito, our senior counsel and director of content, to walk us through the substance of the program.
Thank you so much, Mark. Just for a little bit of quick context before we jump into the meat of this. So again, I'm Frank DeVito. I'm senior counsel at Napa Legal. I've been involved in not the preliminary research that led to the first Faith and Freedom Index. I came on board with Napa Legal about 3 months before we launched it. So I was given a pile of research and helped turn it into what became the final product. But I'm joined by John Peiffer, who is our longtime president and general counsel. He's a co-founder of Napa Legal and is now our vice chairman, and is also a seasoned expert attorney working with churches and nonprofit organizations. And then Father Anthony Pillari is also on the call. I'm glad you were able to make it and get through the tech glitches, Father. Father Pillari he brings a unique experience, and we wanted to include him on this. He's a fellow with Napa Legal's Good Counselor Project. He's studied both canon and civil law, and also has been involved in the formation and now the running of more than one faith-based nonprofit. So his practical perspective on how these laws play into the practical running of religious organizations is really valuable. So I think at this point, maybe John, we'll start with you to just give a little bit of an overview of the index, what it is, how we got here, and we'll dive into the results.
Thanks, Frank. So at Napa Legal, one of the things that we've always been focused on is analyzing the law as it is and providing guidance to faith-based organizations, various kinds of religious organizations, and specifically those that are 990 filers, those that are not generally classified as churches or religious orders or integrated auxiliaries of churches, but that have been formed for religious purposes, but that nevertheless have a requirement to file the annual information return, to provide them guidance on the law as it is, and to provide education and tips on compliance issues and things like that. So a few years back, when we first decided to develop the Faith and Freedom Index, one of the things that we wanted to look at is if we could take an opportunity to analyze the law as it is and evaluate the various states specifically on their openness to faith-based organizations that are 990 filers, those that are not classified as churches, religious orders, etc., their openness to them from a religious liberty standpoint, as well as from a regulatory standpoint, because the various regulatory laws that we'll talk about a bit in this press conference can have a significant impact on the ability of an organization to operate as well as on its ability to take important actions at critical points in the life of the organization. So, with that understanding, we decided that we would take our various summaries of the law as it is that we've developed over the years and turn those into an evaluative tool so that we could ultimately grade the states, if you will, on their openness to faith-based nonprofit organizations, both from a religious liberty standpoint and from a regulatory standpoint, and then to rank them so that this becomes an opportunity for states to evaluate themselves relative to their peers and to look for opportunities to open up their state legal and regulatory regimes to make them more open to faith-based organizations because of the significant positive impact that they can have in states through their service of the poor and disadvantaged, as well as the significant impact that they have in developing young people in education and a variety of other ways that we're all familiar with. I'll hand it over to you, Frank, so that we can jump into some of those examples.
Great. Yeah, I just want to make two kind of caveat notes that I think respond to questions or criticisms that we've gotten in past years. So one is the question of political climate or culture in a state, right? Because you'll look at the results of the index, which will go live right after the press conference, and see that there are, don't want to get political because it's a nonpartisan study. We try to be as objective as we can based on what the laws in each state are, whether that's a red state or a blue state. So you'll see blue states that have gotten some good scores on some criteria, right? Because they have good laws on the books. And conversely, you'll see some red states with some pretty bad scores and laws. And the criticism we'll often get is, well, aren't these scores a little bit unfair? This state, it might be really low in your rankings, but they're not going to, go after me or enforce an action for lack of charitable registration for my pro-life pregnancy center or classical school. The climate's just much better. Don't you take that into account? And the answer is no, we don't, because this study is trying to do something particular, which is point out what are the laws on the books in the state. Because if a state has a bad or a political climate hostile to religious organizations, you need those good laws in place to offer some level of protection, even if enforcement's going to be maybe more aggressive than in other states. And then conversely, if you have a state that's friendly to religious liberty in its current administration, all the more reason to pass good laws so that the protections afforded to religious organizations by a good climate can outlast a political regime. So this is not a study that's telling you, oh, look at this state got the highest score, go incorporate your nonprofit in Alabama or Kansas. There may be benefits, but for one, this is mostly an advocacy and an educational tool to show you what is the lay of the land in each state. And it's also going to be a little bit dependent on where your organization actually operates, right? Like if Alabama has the best laws in the country and in many of our factors here, that you might not be, first of all, it doesn't mean you should pick up and move because you're from a place. But second of all, a lot of those laws are going to require actual operations on the ground in Alabama, right? So if you're functioning as an organization in Michigan or Colorado or California by trying to, deciding to be an Alabama nonprofit corporation, doesn't mean you're going to get all the benefits because you're not physically there. So that's one thing, just not to put too fine a point on it, but this is not telling you where to pack up and move to. This is not analyzing the political climate, but this is about a very objective analysis of, are the laws on the books helpful or hurtful to religious organizations in these states? And then the other thing I just want to briefly address, because I think this was maybe for a certain crowd, but somebody came up to me after our launch event last year, and it was joking, he's a friend of mine, but said, so I see what you're doing here. You're advocating for protections that are mostly going to help big left-wing NGOs to have an easier time doing whatever they want to do. And obviously that's not what the intent, but nor is it the reality. I would say for two reasons that I want to point out. For one, the weeds can get in with the wheat. And, if there are organizations that are nonprofits or religious nonprofits and they're doing work that we might politically or religiously disagree with, that's the reality of a pluralistic society. But the other thing I would say is this index is particularly important for the little guy, and I think with that it'll be a good opportunity to turn it over to Father Pillari and talk about some of his experiences. But the the regulatory things that you have to do, right? Charitable solicitation registrations, audits, tax exemptions, making sure you're following all these corporate governance laws as a nonprofit. The bigger and more savvy and sophisticated the organization, the organizations who are bringing in tens of millions of dollars, they're going to have the least trouble complying with all of these because they have the staff, they have the resources to deal with it. The organizations who these really tend to hurt and burden the most are the smaller ones. Think your local classical school or your neighborhood pro-life pregnancy center or the soup kitchen that's run by the church down the street. So it's worth pointing that out, that regulations tend to most affect those who don't have the resources to deal with them and comply with them. And with that, Father Pillari, I'd love to turn it over to you and hear some of your big picture thoughts. Yeah, thank you.
Thank Wonderful. Thank you, Frank. And I'm thrilled to have the opportunity for all the organizations who are listening to us right now to highly recommend Napa Legal. It's been invaluable, the free resources that are available there to help your organizations. I myself, this press conference, I find myself right at Omaha Beach here in Normandy. I'm leading a pilgrimage at the moment. And I can't help but think how much of an analogy there is between just an hour ago. I was at the cliffs of Pointe Hoc, which is where the Army Rangers parachuted in for a very difficult raid where they took 50% casualties just a few hours before dawn on D-Day. And that raid was possible thanks to great sacrifice, but also thanks to tremendous preparation, going back years, many years, all the preparation of the Army Rangers, developing their skills, and then the immediate preparation. And I imagine a lot of the organizations listening to us now and countless organizations throughout the country are using great ingenuity, great sacrifice, but extremely thin. And I can't recommend enough the resources that are available to help us prepare even more intelligently, especially when you may not be right now, please God, facing a tremendous fight. Hopefully that's your situation. But the behind the scenes work that we can do in the legal realm can make a tremendous difference, will make a tremendous difference when it's necessary to defend faith and freedom. And so in that regard, I could say a bit about the classical school aspect, if you wish, Frank, or I can hold off on that till later on. I think we're going to speak a little bit about the different state levels of the RIFRA, and I don't know if you want to touch on that before I speak, or if you want me to dive into that now.
No, why don't you talk a little bit about your experience with the school first? That would be great.
Great. Wonderful. So I'm blessed to be involved in a classical school in the state of Kansas, a wonderful school called St. Martin's Academy. And there are initiatives all over the country. So many people who are either starting schools or different educational initiatives for children. And as most of you listening to us are probably aware, being able to present courageously teaching in harmony with the natural law, in harmony with the faith, harmony with the biblical definition of marriage, for example, is something that at any moment you could come under attack. And so it's very helpful when, in our own case, for example, we looked at, with the resources of Napa Legal, right away at what Kansas's situation was. And we discovered that there is a state religious RIFRA, which protects religious freedom at the state level more robustly. However, it's a statute. It's not the constitutional level. And even though Kansas, by and large, is extremely friendly towards faith-based organizations, those in office can change at any moment. And so that was very helpful for us to go the extra mile to begin talking with some other schools, even universities, who had very carefully crafted their statutes to make very clear what the expectations were from anyone working for the school in terms of living in harmony with or not publicly dissenting from, but rather supporting the faith in question, the Catholic faith in our case. And so that type of preparation behind the scenes, even though there's no difficulty right now, can be extremely helpful when difficulties arise. And if I might, I'll add just one other point, that with so many organizations I've worked with, I've seen how even with people of goodwill, there can be real surprises. Someone who you never might have expected winds up feeling that they should advocate for a position on marriage that is contrary to the church's teaching, or there's a disgruntled employee and miscommunications, and all they're attacking the organization in some way, even if not based on fact, ultimately. And so the more the organization is very well prepared and structured in terms of its mission and how that's clearly conveyed in its documents, but also even in terms of the civil structure itself, which I think we're going to touch on a bit later on. So those are elements which for us have been extremely important, and I can't recommend enough to all those who are listening to us today.
Thank you so much, Father. So we're going to jump into some of the results and the actual factors in the analysis. I'm just letting you know, because I know it's mostly almost exclusively journalists on the call. So if you have particular issues, factors, questions that you would like to bring to the panel, it's a webinar, so you can't speak. But if you drop them into the Q&A or chat function, the earlier the better, just so I can keep track of whether we have questions, and we'll prioritize, make sure we get to them. So with that, I want to talk a little bit about, we're going to divide up what our comments into two sections here, based on the division of the Faith and Freedom Index itself. So you'll see in the study that we have what we call religious freedom factors and then regulatory freedom factors. And they're a united whole, right? These are all the laws that we've found that we think most help or hinder the ability of religious organizations to function on the state level. So the former, the religious freedom ones, you're going to be looking at, are there religious exemptions to quote unquote non-discrimination laws? Is there a Religious Freedom Restoration Act on the books in that state, and so on? The regulatory side is going to be more the nuts and bolts, what we fondly call the boring stuff at Napa Legal. So charitable registrations, other regulatory requirements, tax exemptions, corporate governance laws, and so on. So we're going to start with a little bit of the more hot button side on the religious freedom laws, and then we'll get into the boring stuff's not really boring. It's actually quite important, and we'll hopefully make that case in just a few minutes. But I want to start particularly by talking about the Religious Freedom Restoration Act. It's the one of the most heavily weighed factors. Obviously you have to make judgment calls about which scores, which types of laws are going to get the most weight when you're scoring an index like this. And the reason we do that is the Religious Freedom Restoration Act it's not sufficient to solve all of the needs of a religious organization, but we think it's a necessary backstop because it can step in as an important help when there are not other laws that should be on the books, in our opinion, on the books. So for the 30-second version, for those who are not familiar, the Religious Freedom Restoration Act, it's a response to a series of Supreme Court cases from 1990 through 1997, where basically the Supreme Court ruled that if a law passed by a legislature, Congress, and then at the state level, the state legislature, if it's generally applicable and neutral, right? The law doesn't say Catholics may not buy wine for mass, right? That would not be neutral or generally applicable. It's not neutral, it's pointed at Catholics. But if you have a general law, right? No purchase of wine, period. It's not applicable to a specific group. It's very broad and general. The Supreme Court ruled that if that law is generally applicable and neutral, it's not a free exercise issue that warrants strict scrutiny under the First Amendment. So basically, a lot of protections for religious organizations there are lost if the law is neutral and generally applicable. The Religious Freedom Restoration Act is a statute that attempts to fix that problem by saying if a law is neutral and generally applicable, even so, if it burdens free exercise, then courts have to treat those laws with the highest scrutiny. So it's an important protection across the board, right? Because you can think of many examples, right, of laws that may appear neutral and generally applicable that are in fact burdening religious exercise. That could be a state order during an emergency or a pandemic that shuts down churches and religious organizations and their operations. Looks to be generally applicable, right? It's not targeting just religion, it's everyone. It could be non-discrimination laws at the employment level. I always do use scare quotes because I think it's a bad term when we say non-discrimination, but that's the common parlance, right? So if you have a law that says you can't make decisions in hiring or promoting or firing, or on the public accommodation side, you can't make decisions about who attends your programs on the basis of religion, sex, sexual orientation, gender identity, and all these other protected classes, even if that effectively means that a religious organization is not allowed to hire or do programming in accordance with its religious beliefs and principles, what recourse do you have? So a lot of the laws that we touch on are asking whether there are explicit protections for religious organizations, right? To use the employment situation, many states will say, notwithstanding our employment non-discrimination laws, religious organizations are allowed to hire in accordance with their tenets and principles, right? But not all states have that. So that's just one example. It's a really important protection to have proper religious exemptions or exclusions from these kinds of laws. But if a state doesn't, then the Religious Freedom Restoration Act is a really important backstop, right? The ideal is that you don't have to go to court and sue and see if you have a right to hire in accordance with your religious principles. But if you have no other choice, there's no statutory protection against that employment law or public programming law. You at least can bring a challenge under the Religious Freedom Restoration Act and say, this may be a neutral, generally applicable law on its face, but it burdens our religious organizations' exercise of religion, and therefore courts should apply a high degree of scrutiny. And if you have a Religious Freedom Restoration Act on the books in your state, which now I believe it's 29 states plus Washington, D.C., because it's federal, have some form of Religious Freedom Restoration Act protection. So 20 states do not. That could be the make or break between whether you actually have a backstop protection against quite a number of laws that can burden religious exercise in practice, even if not explicitly. John, before I go on with practical results, do you have anything you want to add?
The one thing that I would say is that, and this kind of gets back to a philosophical approach that we took with the index, is that with each of these individual factors, as I just wanted to underscore again, I think something that Frank said early on, we're looking at them in a vacuum. So whereas in one state, if they don't have a Religious Freedom Restoration Act, they may have certain other laws in effect that, as a practical matter, would provide some of those same protections in a particular circumstance. We're nevertheless looking at each of the factors that we've identified in a vacuum and saying, does that state have one? Does it not? If it does have one, does it afford the greatest level of protection that the conception of whatever that factor is, is it accomplishing that? If not, what are tweaks that could be made that would help to better accomplish that? I'll give one example. So my home state of California does not have a Religious Freedom Restoration Act. As Frank alluded to, one of the ways that a Religious Freedom Restoration Act could be a valuable tool is in the context of employment-related disputes. However, in California, which does have a separate body of law for nonprofit religious corporations, if you were a nonprofit religious corporation, then by definition, you are not an employer, quote unquote, for purposes of the California specific non-discrimination law that affects employment. So and that's just one example. And in each of the states, there may be those circumstances, but what we're ultimately trying to do is build a complete picture of, in the sort of Platonic ideal state, what are the variety of different kinds of protections that Platonic ideal state would afford. And so that's the importance of looking at each of these factors separately, even though an enterprising lawyer, if your organization were faced with an issue in that particular state, may say, well, door A is closed, but we've still got door B or door C that we can potentially go through. That doesn't diminish the impact of each of these. What it says is each of these factors is sort of a different arrow in the quiver, if you will.
Thank you, John. Father Pillari, I know you had mentioned when we spoke before this that the existence of a Religious Freedom Restoration Act you think is quite important as somebody involved in the work of faith-based nonprofits. So do you want to talk a little bit about that?
And if Frank's not shying away from hot button topics, and so as we're aware, the concept of marriage, of what a man and a woman is, all these things are very much debated, if you will, in our society today. And so in any educational institution, it's not simply the children you're dealing with in front of you or their families, but it's extremely common that they may and they will ask questions in the classroom where you're responding on the teaching in question, and they may have close relatives, friends, people who may be upset by that. And so the Religious Freedom Restoration Acts that Frank is referencing in the states are very helpful because the federal if the dispute in question were to involve it is not involving the federal government, if it's not involving a federal law, but it's at the state level, the state may say, well, even if there's at the federal level the protection, that just doesn't apply here. You can't call on that in your case in question in court. And I defer to the minds who are practicing more than I am in that area. And so having a Religious Freedom Restoration Act, which, for example, in Kansas, it's at the statutory level, which is already a help. It is there. You can use it right now, but it could also be gotten rid of more easily in the future because it's not a constitutional amendment. Whereas if it rose to that level, and some of them, it might only be Alabama right now, but some of them have, and I hope many more will have provided that if you win your case, even against the state government, you can have reimbursed your legal fees, which for small organizations is extremely helpful. And so there certainly is wonderful work that could be done to create more protection for what's such a fundamental freedom in our country, which is religious liberty.
Yeah, that's a great point. So I think before we wrap up on this and go into the boring stuff, no, the corporate governance and the regulatory side, I think that you made a really good point, Father, that the while most of the Religious Freedom Restoration Acts that have been passed over the years, especially in the late 90s, early 2000s, in response to the Supreme Court cases, they've mostly mirrored the federal Religious Freedom Restoration Act, which is good. It gives strict scrutiny protection to burdens on religious exercise. But there have been a couple in recent years that have added helpful provisions. So not all Religious Freedom Restoration Acts are exactly alike. We think Utah passed one in 2024 that we think has two really important provisions. One, Father, you had mentioned is the attorney's fees provision, that if you prevail, you can recover attorney's fees, which is important because often you're going to have, again, a small classical school or a small charity of some sort that doesn't have a ton of resources. But if they can bring in attorneys who can get their fees reimbursed if they prevail, it allows these little religious organizations to have maybe a little more legal firepower if there's the promise of attorney's fees upon victory. And then the other thing that's really important, and we've seen a problem here in recent years, is that so Utah again has done something creative, and a few other states have it. I believe Wyoming has it as well. But there's a provision that the government does not need to be a party to the lawsuit in order to invoke the Religious Freedom Restoration Act. And that's very important, right? Because the understanding is that the Religious Freedom Restoration Act is supposed to be a way to respond to government action that is burdening religious exercise, right? Makes sense, because it's not a private right, a right that we're talking about enforcing on private parties and their relationships. The problem, though, is that states will often act, right? They exercise their state action that burdens religious liberty by passing laws, right? Like the employment non-discrimination law is a great example. State passes a law, says you can't discriminate on the basis of all these classes, including sexual orientation, gender identity. There was a case recently in Virginia a few months ago where a employee was terminated from a Christian school because he'd signed a statement of faith agreeing to all of these things and then announced that he was transgender, and I think was going to get some kind of a surgery, or was at least being public about it. And the school, the organization said, well, this violates the statement of faith that you signed and we're going to terminate you. Employee sues the school. And you see the problem here is that one of the defenses in this case that the school tried to bring up is Religious Freedom Restoration Act, right? This state action, the employment law, violates our religious exercise. And the judge in the district court case there he said it's a good decision, actually. He says, I acknowledge this. This seems like the kind of thing that Religious Freedom Restoration Acts should be for, right? It's a neutral law that in fact burdens religious exercise. Problem here is that the government's not a party. It's fired employee versus school. So we can't have a Religious Freedom Restoration Act claim, and I have to throw it out. So some states have responded to that, again, including Utah. I think there are a couple others that do make it clear that you don't have to have a government party to bring the Religious Freedom Restoration Act claim or defense into the lawsuit. So, keeping in mind that the Religious Freedom Restoration Act protections, they flow down almost any other problems that you're going to see with other types of laws, non-discrimination laws, lack of funding for religious programs, some of the regulatory and tax things that we'll talk about. Religious Freedom Restoration Acts are always kind of a backstop that you can often use if religious exercise is being burdened. But that being said, we want to now get into a few of the nuts and bolts of some of the other factors that we cover in this. So I want to turn your attention to two. I'm going to talk a little bit about corporate governance laws, right? So these are the codes at the state level. Every state has some form of them, right? Most states have a nonprofit corporations code that gives the, what do you need in terms of bylaws, in terms of indemnification and insurance, in terms of board of director and officer requirements, all the things that you need to run a corporation. What are the requirements? And most states have a separate code that applies to nonprofits, separate from the for-profit side. Not all. There are some that just have one single code that applies to both, though that's more rare. California actually has a distinct religious nonprofit corporation code, which is separate even from the regular nonprofit code. So that actually, again, we usually like to pick on California when we're talking about religious freedom protections, but it really does have the gold standard in terms of corporate governance laws that help religious organizations to form and have protections in accordance with their religious principles as distinct entities from a nonprofit. So I know, John, you'll probably talk a little bit about the corporate governance stuff. I have a couple examples I want to give, but do you want to talk about the corporate governance codes in general?
Yeah. So as Frank alluded to, a handful of states have a separate body of law that is specific to religious organizations, in particular, California, again, the state where I practice day to day, has a completely separate Nonprofit Religious Corporations Act that actually does have some significant differences from other kinds of nonprofit corporations in the state with respect to the scope of the Attorney General's oversight of the corporations, for example, with respect to circumstances under which there may need to be governmental approval before taking a corporate action. I think Frank is going to talk a little bit later about the new major corporate actions factor that we incorporated into the Faith and Freedom Index this year. But in the case of California, for example, the sort of limited scope of the governmental authority over those major corporate actions flows from the fact that there is this separate body of law that governs religious corporations. Then there are some other states that permit the express formation of religious nonprofit corporations, but they don't necessarily have a separate act, if you will, though there may be some specific provisions of the law that differ. Here I'm thinking of states like Wyoming and Indiana in particular, where they do have religious corporations and may have specific provisions of the law that differ, for instance, with respect to things like membership in the corporation. So for those that don't have a background in nonprofit corporation law, nonprofit corporations can operate. So first off, nonprofit corporations exist for purposes, for permissible tax exempt. If we're talking about 501c3 tax exempt organizations, they exist for specifically permissible purposes, things like religious, charitable, public safety, scientific, educational, literary purposes. Okay. And then the governance of those organizations can be a single tier, a board of directors that has a fiduciary duty for ensuring that the organization operates in a manner that is consistent with those purposes. Or in some cases, an organization may have two tiers of membership, or of governance, where they have that board of directors with the primary fiduciary duty, but they'll have another tier of governance, which in nonprofit corporation law is called membership. And membership is sort of the nonprofit analog to shareholders. They exercise the kinds of rights that we would generally associate with shareholders, but they don't own anything because, again, the organization exists for purposes. So what sorts of things am I talking about? They're things like exercising powers over the election of directors or over amendments to the articles or the bylaws of the corporation or approving or disapproving of a proposed corporate action, things like that. So in the context of these types of organizations under the laws of some states, there are certain powers afforded to directors or members that are unique to religious corporations, or limitations on powers that are unique to religious corporations that may not be the case for other kinds of nonprofit organizations in that state. Again, a minor example, or maybe not so minor example, depending on the circumstances. I'll use California as an example because it has the most developed nonprofit religious corporation law. There are certain kinds of lawsuits that can be brought by directors, by officers, by members of the corporation, or by former members of the corporation or former directors of the corporation for sort of generic secular nonprofit corporations. The scope of those permissible activities are more limited for religious corporations, understanding the sort of unique constitutional issues that are posed for religious corporations. There are differences in terms of the terms that they can serve. There are differences in terms of whether there are individuals who are sort of external to the governance of the organization, who may be required to approve certain transactions. So here I'm thinking of, if I look at this in a Catholic context, for example, it's because of requirements related to canon law, there may be some body that's independent of the organization that has to approve certain kinds of transactions. Well, those kinds of requirements are sort of contemplated by the Nonprofit Corporation Act itself. And you see similar things in other states. Another great example that we see in California, Wyoming, and a number of other states relates to differences in how the fiduciary duties are imposed on directors if they are directors of religious corporations versus other kinds of nonprofit corporations, where the religious corporation or the corporation formed for religious purposes, its directors are permitted to look to religious authority as one of the bases for ultimately making a decision in accordance with their fiduciary duties. So these are important protections for the directors of these kinds of corporations because there may be external requirements imposed on them by, for example, canon law or the broader statutes of a denomination, things like that. And those have actually been contemplated by the secular corporate law in states that have taken a more thoughtful approach to developing a body of law that specifically takes into account the kind of the quirks, if you will, of religious organizations.
I just want to thank you, John. I'll give two quick examples of some corporate governance issues that maybe at first appear to be like technical and what does this have to do with religious freedom and religious orgs, but you can see the practical application with an example. So one thing is, so this year we added a new factor that we hadn't previously done before. So a lot of new research and work on our end to get this one up and running. But we wanted to evaluate in this factor this year was what requirements state governments put on major corporate actions. So you think of if a nonprofit needs to dissolve, if it wants to merge with another nonprofit, if it wants to sell substantially all of its assets, if it wants to amend its articles of incorporation, its governing, its formation document, um, does it need to do anything? And the answer in some states is yes. In some states, you actually have to either give prior notice, which in some cases makes sense, especially if you're, moving from a nonprofit to a for-profit corporation or merging a nonprofit with a for-profit corporation, then, the government, like the state attorney general signing off on it makes sense because you've gotten all the advantages of tax exemption and donations, and then all of a sudden to roll that into a for-profit, it maybe warrants a second look or a close look from somebody. But a lot of states do go beyond this. You'll have 60, 90, as much as 120-day provisions in some cases, where even doing something as basic as merging a nonprofit with another nonprofit you have to give the state attorney general notice, or you might even need their consent. They have up to 120 days to consent that's Michigan, right, John?
Yeah, I mean, I can give a practical example of that.
Yeah, please.
A couple of years ago, I was merging a Michigan nonprofit corporation into a California nonprofit religious corporation, and the surviving entity was going to be the California Nonprofit Religious Corporation. And California, which I don't think anyone would say that it has a reputation for being light from a regulatory standpoint. Simply it did have a notice requirement. And on 20 days notice, assuming that there was no objection from the Attorney General, we would have been able to proceed with the merger. In Michigan, however, the Michigan Attorney General has up to 120 days to sign off on a merger. And if they have not provided any response by the 120th day, then you can proceed. They may respond sooner, in which case, if they do respond sooner, then you can proceed. In our case, practically, I think they responded around 90 days after we had made the application. But the practical effect of that was these organizations that had already decided to merge, to combine operations and finances, were sort of in this limbo period for about 70 days, where they were essentially already combining their operations, even though they hadn't been able to complete the legal steps to officially do that from a legal standpoint. This could be a particularly difficult situation for an organization that finds itself in financial difficulties, where it may need to take corporate action sooner rather than later, or the organization may actually be in danger of being unable to continue its operation, which means that whatever purposes were originally intended or activities that were originally contemplated for the organization could find themselves being completely unwound. So it just creates this difficulty and sort of an unnecessary delay in particularly where, and I think your point's well taken. If we were talking about combining a nonprofit with a for-profit, huge red flags because of concerns around private inurement, the idea that, or private benefit, the idea that a for-profit or private individuals would benefit from the tax exempt status of an organization. There are huge red flags there. So understandable that a regulator would be concerned about that. But where you're talking about two tax exempt organizations that have compatible purposes merging with each other, that just doesn't raise the same kinds of concerns. And so it imposes this this difficulty that could have a serious impact on finances and operations.
Great, thanks, John. One more corporate governance example. This will be a very brief one, but I think it just helps to highlight how little technical aspects of a corporate governance law that no one would really think would be a religious freedom issue can have a big impact. So another thing that we explore in our corporate governance factor is, are there provisions that explicitly recognize and differentiate a religious organization from from the requirements imposed on nonprofits or corporations generally. And some of them are important. In particular, most states will have some kind of a minimum number of directors on the board, right? So you can see the reason for it. You might want at least three, or three, I think, is a common one, because it seems like a pretty common sense check on making sure, okay, this is not a for-profit company. It's not owned by private owners. It's a nonprofit with a religious or charitable mission. It's getting donor dollars. We want more than one set of eyes overseeing where the money's coming from, where the money's going, and so on. So, okay, understand the reason for it. What about religious organizations that are formed with the intent that an ecclesiastical superior, right, according to canon law or the traditions of a certain religion, that the superior is the one who controls the organization, right? For Catholic organization, you might want to found a nonprofit and say, okay, it's just the bishop is the voting director, or just the pastor of a church in the Catholic Church or in another denomination. What do you do? There again, can you go back to a Religious Freedom Restoration Act issue and say, well, neutral law, we get it, but it's burdening our free exercise? Maybe. But there's an easy statutory fix, right? That you just carve something out, recognizing that religious corporations will often have different circumstances. One example, Idaho has this in their nonprofit corporations law, and it's quite simple, right? The board of directors must consist of 3 or more individuals. Notwithstanding the foregoing, the board of directors of a religious corporation must consist of at least 1 individual, right? So easy fix, 2 sentences. But again, there are a lot of these that you might wonder, oh, why a carve out for religious corporations? But there's often more to it. And this could be literally the ability of a religious organization to be overseen in the way that accords with canon law or the traditions of that church, being simple or quite difficult to figure out whether you can legally do that. So with that, I know we have a lot of other regulatory areas that we'd like to cover. You can view the results of the index yourself, and I think we're going to publish the new results right after this call. So at noon or just after, it will go live, and you'll be able to look for yourselves. But I think before we wrap up, Father Pillari, I think we would like to hear a little bit from you on some of these regulatory factors and how you've dealt with them working for nonprofit organizations.
The points that Frank and John were just highlighting are extremely real for especially for small nonprofits. And to cite 2 other examples, the charitable solicitation registration requirements across the country, what that means is that if any organization has even a website which can be accessed by any state across the country, then your organization really needs to be registered in all 50 states. And that is quite expensive for a small organization. That can cost between $5,000 to $10,000 to do that. States have different requirements, and so quickly being able to find out what the requirements are. I also should mention that the Napa Legal All Access is a very helpful resource for behind the scenes work in terms of corporate structure and things like this. So there's registration, and then there's also an audit requirement. So if your organization receives over a certain amount of donations in the year, for example, in Kansas, that number is $500,000. In California, it's $2 million. So if you cross that threshold, then you need to have a formal audit done, which could cost $15,000 or $20,000 depending on the requirements. And then that audit may also begin to require that you incorporate what's called GAAP accounting. And so a certain standard of accounting principles, which can involve more advanced software. All of these things can be extremely costly, especially for an organization which may have a small staff and is trying to very carefully use donors' dollars for the mission versus administration. And so without going into all of the details, once an organization becomes aware of these different requirements, and Napa Legal really facilitates how at a glance what these are, how you can deal with different states, then the organization has the possibility of being creative. For example, if it's an organization which could have a relationship with, for example, the Knights of Columbus, or another organization that might be willing to say, we will set up an arrangement to receive donations designated for you, and those will be passed on to your organization, but in a way which now all across the country, those people are donating to a well-established large organization so that you don't have to register. in the 50 states. And I'm not, to be clear, I'm not offering formal legal counsel to your organizations right now, but these types of things become possible. Or for the audit requirement as well, there are ways that the organization can become creative. If, for example, if you were a media-based organization where incorporation in a particular state, you might have a number of options as to where you incorporate. And you said, well, California has a $2 million threshold for its audit requirement. If we partnered with an organization such as the Knights of Columbus, where from other states we're not soliciting, we're not receiving directly donations from other states, but we do want to do things maybe locally in California, we're not crossing the $2 million requirement. All of a sudden, then you might have saved a for your organization. So these types of things, which especially as a priest, where you try to focus on the spiritual life, and many people leading nonprofits are want to focus right on the mission. Seemingly material or less important things can make a tremendous difference in not only avoiding difficulties, but allowing you then to really make the best use of the funds you have for the mission that donors want it to go towards.
Yeah, thank you for bringing up the charitable registration issue, Father. The one thing I would say on that, as I think both Father and Frank alluded to earlier, within our Napa Legal All Access, we have what's referred to as the multi-state compliance matrix, which provides summaries of and then links to sort of practical guides on how to accomplish several of the items that in each of the 50 states plus the District of Columbia that sort of tie in with the Faith and Freedom Index. So with respect to charitable solicitation registration, for example, in the multi-state compliance matrix, we provide the summaries of law, and we also, through Frank's great work, have published a variety of step-by-step instructions for organizations to do this. But one of the things that we've teased out in the multi-state compliance matrix is that handful of states where I'm not aware of any state that requires an organization like a church that does not file the Form 990 that I mentioned earlier. I'm not aware of any that require them, except in certain limited circumstances, to do charitable registration. But one of the things, and there are other guides available that sort of capture that category of excluded organizations. But one of the things that we wanted to focus on is specifically organizations that are 990 filers, but that are formed for religious purposes. And there are a handful of states where organizations that fit in that category are also excluded from charitable registration. So that's a compliance point that can be analyzed through the multi-state compliance matrix. And then with FFI on that point, what we're doing is taking that body of research and now turning it into an evaluative tool to look at which states are more open and make it easier for organizations who are formed for religious purposes to do fundraising in that state versus those that may, notwithstanding that they're formed for religious purposes, still impose some kind of registration requirement on them or an audit requirement, which, as you said, can be a really expensive undertaking for a small organization and can actually put an organization in the position of deciding whether to accept or reject a gift from a particular state if it's a state where they weren't going to have the compliance obligation otherwise. I'll give the example of, in our own case, as an organization, Napa Legal, receiving a gift from the state of Wisconsin triggered an audit requirement that we would not have had otherwise because California expressly excludes religious corporations from the audit requirement. So suddenly the acceptance of that gift triggers a $15,000 to $20,000 obligation, as you said, and it sort of puts you in the position of having to make a prudential judgment about whether the gift is significant enough to warrant the additional administrative and compliance costs.
Yeah, thanks, John. I know we're about coming up on time, so I don't see any outstanding questions. If anybody has any, we've got a couple minutes left if you want to drop one in, but also you can reach out offline after you've actually viewed the results, and we can answer any questions and follow up via email. So just to conclude, I just want to say, for one, thank you for attending. But as a practical takeaway, you'll see the results come online in a few minutes. And you'll notice that the states that have scored the best, their score is not 100%. It's not even close. And the takeaway is, right, every state has the ability to pass better laws to protect religious organizations and allow them to thrive. And we'll say the difference between a theoretical state that would get a 100 on the Faith and Freedom Index and that would get a 0 on the Faith and Freedom Index, I think we've made the case from Father's practical examples, John's in the trenches experience. It's not a little bit. It's make or break, right? If you have 100% score, an organization is left alone to make its decisions, its hiring, its internal operations, according to its faith, without being burdened with thousands of dollars in fees and audits and paperwork and burying, personnel in doing these compliance things. There's going to be so much more ability for those organizations to do the work that they're supposed to do. And we think that beyond obviously we're a Catholic nonprofit organization and we care about religion in the public square, but even for those where that's not your primary issue, just the sheer amount of work that gets done by faith-based nonprofit organizations, educating our children, feeding our hungry and housing our homeless, and taking care of, single mothers who are in problematic circumstances all across the board. The amount that's done for society by religious organizations is huge. And so unchaining them so that they can actually do this work without spending their time and their resources on all these administrative burdens and the fear of lawsuits and all of this, it's a really huge difference, not just for the good of religious organizations themselves, but for society at large. So it looks like we're coming up on time. Does anyone have any last words before we wrap up?
I just want to thank you, Father Pillari, John, and you, Frank, for just a really substantive and informative hour here, as well as go to napalegalinstitute.org. You can see when this goes live just in a few minutes. If you follow us on our socials, you'll see it there as well. But we're interested in your feedback and hope that it's going to be a tool that's going to really, among the other resources we provide, be valuable to those nonprofits that are really trying to push their mission forward and protect their organizations. So please continue to follow us. We look forward to many more exciting endeavors like this and hope that you can connect with us in the years ahead.